afternoon. Welcome to the Thurston County Board of County Commissioners Board Work Session for Wednesday afternoon. It's June 23rd, 2021, 2:03 p.m. My name is Ty Menser, Chair of the Board. To my left is the Vice Chair, Commissioner Gary Edwards, and to my right is Commissioner Carolina Mejia. To Commissioner Edwards' left is the County Manager, Amir Chavez. And we've got Travis Burns from our Prosecuting Attorney and Jennifer Davis from our Community Planning and Economic Development Department. I see Caitlin Nelson and a couple other folks up there.
Grace O'Connor.
Grace, yes, okay, Grace. And is that Ken?
Ken Feldman.
Ken, yeah, okay, good to see you, Ken. The topic this afternoon is the wireless code update. It's an informational briefing. It's slated for an hour. The public can follow along on a live stream on the Thurston County YouTube channel. That, I'll let the county manager say his
Thank you, Commissioners. Sound check, can you hear me? So this is a long-time comment, at least from my point of view, it's just bound to happen. When the FCC passed new regulations related to the wireless communications, there was a need for the county to start aligning the code related to the new FCC regulations. There's a lot of history. And Ken Feldman, hopefully, can give us a perspective on the history of the new the FCC regulations. The county itself has been involved, not just at the county level, but perhaps at the national level in challenging some of the FCC regulations over the last 3-4 years. I can't remember. So when I think what I said is bound to happen is how we're going to start aligning the county code to the new regulations. And I think that's how we seems to have an interesting conversation, at least perspectives from some members of the public when this conversation came from the Planning Commission. There is a lot of nuances on this particular FCC regulations and what the county's options are. This is just my perspective. Seems to be very limited in terms of the options of flexibility that perhaps the county may have in terms of updating the code. So I'm looking forward to this conversation and see where it goes. I believe one of the recommendations as a result of this briefing, based on the Planning Commission public hearing, was to stand public citizens advisory group. They hopefully will guide through the implementation of changes of the new code. Anyways, that's my understanding. Jennifer?
Yeah, I'll take it away for a minute and then let the other members of the wireless code update dream team here help out. But Jennifer Davis, Community Planning Manager with CPED, and here with members of the Prosecuting Attorney's Office. The consultant the county has hired, Ken Feldman, to help us out on this very complex code update, and then Caitlin Nelson, who is our lead planning staff. And this is a docketed project. It's been on the docket since 2014 as a code update. We have been moving forward more in more recent years to get our codes to align, as County Manager said, with the federal laws around siting of wireless communication facilities in our community. And where this code update is right now is that it's at the Planning Commission and it's under review by the Planning Commission. And the Planning Commission held a public hearing on a draft code update on June 2nd. And they received many comments. I think there were 67 at the time of that written comments, and 6 folks testified at that hearing. And the community has a lot of concerns, and I know the board's been receiving a lot of those community concerns directly to your board office and in testimony at your meetings. So staff felt like we needed to have a check-in with you to make sure everyone was on the same page in terms of knowing what this topic is all about and what the county's working on, and sort of the next steps in the process. In addition, the Planning Commission at that public hearing, they don't have any recommendations on the code itself. That's still in process. And they have several work sessions that'll be coming up for them in the coming months. but they did make a recommendation to the board, which is attached as part of the materials for today, to consider standing up a citizens committee to look at this draft code update. They received a lot of input from folks during their review that asked for a citizens committee to get involved. And then CPED has provided some sort of initial information around what that might look like if the board chooses to go in that direction, the role they might play, who might be on it, how it affects the timing of the project, et cetera. So that there is a decision point before the board today, which is sort of advising on the next steps that the board is comfortable seeing with regard to this recommendation from the Planning Commission around forming some sort of stakeholder group or citizens advisory committee on this project. One is not currently planned. It was not included in the scope of this project, but it is of course at the discretion of the board to go in that direction if that feels like something that's gonna give us the kind of input that you seek. But before you make that decision, I wanted to give Ken the opportunity to provide basically an overview of what this is all about so that you have the full information about what the federal law says we need to do and where the county is trying to be in compliance with that with our codes and what our limitations are and what we can control and can't control locally around wireless communication facility siting. So that's just my spiel, and I'm going to turn it over to Ken. If Ken, you're prepared to share your PowerPoint, which I think will be really instructive and helpful.
Okay, so let's see. I do that. And can you all see that?
Yes. Yeah, yes, we can see it.
Okay. Well, commissioners, let me say first, thank you for having me. It's nice to be here with you, Mr. Chavez. Nice to see you. My role today is to give you a little bit of the history and the background of the changes, mostly in federal law, that have impacted the need for these code amendments. So let's just jump into it. And then I think all of staff is hopeful that with this background and with some of the other materials you were provided, that you'll be in a better position to understand the context of the Planning Commission recommendation and ask us questions and then make an informed decision. So if we go back to 1996, that was the first comprehensive update to the federal telecommunications laws since 1934. And it was not only about wireless, there were a lot of things covered in that act. It impacted local government authority in a number of ways. And with respect to both rights of way management and land use authority over the siting of wireless facilities, there has been some major impacts. Now, since that time, since the passage of the 1996 Act, there have been additional laws that Congress has passed that have impacted and in some cases restricted or outright preempted local authority over some kinds of siting issues. And then we've had the FCC jump in, particularly during the last administration, and issue multiple orders over a number of years involving new and more restrictive conditions on local control. Basically, if you get the feel for local control being withered away bit by bit, slightly over, since 1996, that's exactly what happened, and it kind of accelerated between 2016 and 2020. We do still have significant local authority, however, and it's very important that the local codes reflect what authority we have and what authority we don't have. In 2003, the county code had some significant amendments, which basically incorporated a lot of the 1996 Act provisions, and then there were some minor amendments done in the ensuing years, but none recently. So let's see if I can go to the next slide. There we go. In the 1996 Act, we have Section 704. Basically, that preserved state and local regulatory authority over the siting of wireless facilities, but within kind of a box with certain limitations. Local regulations cannot unreasonably discriminate among providers of equivalent services. Our regulations, even when they might otherwise be appropriate, cannot prohibit or have the effect of prohibiting the ability of a company to provide personal wireless services. Government actors are required to act on applications within a reasonable period of time. Importantly, and we'll come back to this in a little bit more detail later, no governmental entity, state or local entity may regulate the personal wireless service facilities based upon the environmental effects of radio frequency emissions, as long as those emissions comply with the FCC regulations. And environmental effects has been interpreted in court cases to include health effects. And that when there is a decision to deny a facility or an application, that decision must be in writing and supported by a written record. So no prohibition restriction, you can't have an outright ban. You can't say in these zoning districts, we will never allow any kinds of facilities. Where we get into gray areas and we end up having more debates, and frankly, where there's been more litigation, is does a regulation have the effect of prohibiting? What does it mean to have the effect of prohibiting wireless services? Can we impose conditions that might make it more costly on a provider because we want to make them go to greater lengths to minimize impacts, like designing the site in a way that maintains view corridors or creates a concealed site that won't have as big of an impact on the public? And the answer to that in most cases is yes, we can. We can usually require providers to demonstrate that the site that they're proposing is the least intrusive compared to other sites. Acting within a reasonable period of time, the FCC came out with rules in 2009 that determined what a reasonable period of time was. And they basically, you may have heard these referred to as the shot clocks. These are two of multiple shot clocks the FCC has come up with over the years. If there's an application for a new structure, government has to act on it within 150 days. If it's a co-location, which at the time was defined as adding facilities to a site that has already received approval for wireless facilities, and that definition has changed somewhat, that has to be done within 90 days. If you miss the shot clock, there's no automatic approval. The applicant may go to court and say, Judge, they haven't acted in a reasonable period of time, please make them act. So that's the reasonable period of time issue. One of the issues that we receive and our local government clients receive, and we have probably in the last 3 years worked on 30 to 50 different codes and the same number of license agreements with different companies for access to rights of way and various other siting related matters for local governments. And the issue of the effects of these radio frequency emissions on the public has grown and grown and grown, and it will continue to grow, I think. The federal law provides that the FCC adopts regulations governing the maximum permitted exposure to radio frequency emissions. Most sites under the FCC rules are what are called categorically exempt, which means if they meet these certain criteria, and many wireless sites meet those criteria, they are categorically exempt and they don't need to do anything further. Local governments are preempted by federal law from creating our own rules for radio frequency emissions, but you can have regulations that require proof of compliance with the federal regulations. Now, in 2012, some of you may recall the government was just about ready to shut down, and there was going to be a massive tax increase when certain tax relief was not reinstated, and the Congress came back together and passed this Middle Class Tax Relief and Job Act of 2012. That was about over a 100-page statute, and only half of it actually related to middle class tax relief. The rest of it related to radio spectrum and mostly public safety communications. But there was one small part of it, which was called Section 6409, that went beyond public safety. And it basically said, notwithstanding Section 704, which is that section of the 96 Act that mostly preserve local authority, said a state or local government may not deny and shall approve, right? So we got to do it. Any eligible facilities request for a modification of a tower or a base station that doesn't substantially change the physical dimensions of a site. That was a very short statute that had no legislative history and no definitions for any term. So we kind of finished that. We read that legislation and we thought, well, what's a base station? The statute didn't say. What's an eligible facilities request? The statute didn't say. What is a modification that doesn't substantially change physical dimensions? How much can you change before it's substantial? The legislation didn't tell us. So what happens in those cases is the FCC steps in and starts regulatory proceedings. And in this case, they come out with an order in 2014, and they define what is an eligible facilities request. What does it mean to substantially change a site? Because only two types of structures were named in the statute, a tower and a base station, they came up with definitions that a tower is a structure that is built for the sole or primary purpose of housing wireless facilities. A base station is anything else that can house wireless facilities. So the rooftop of a building that has antennas is a base station. A light pole in a ball field that has antennas is a base station. A water tank that has antennas is a base station. They even define the term, what does it mean an existing site? Because you have to be modifying an existing site in order to come under these new rules that said, in these cases, we recognize if you meet these criteria, the county must approve these applications for modification. All of these new terms ought to be in the code, so planning staff has a much better idea of what kind of constraints they're under and when an application qualifies for automatic approval and when it doesn't qualify for automatic approval. Because I will tell you, a lot of folks in the industry file applications and say, you must approve this under section 6409, when it really doesn't meet all of these criteria. So that's one main area where the code needs to be updated. Now, we've had FCC orders 2018 through 2020. I'm not going to get into these in great detail, but just to highlight them, the first one mentioned here dealt with exemptions and basically said certain environmental and historic preservation laws don't apply to certain kinds of wireless site applications. In August of 18, they said any governmental moratoria over wireless facility siting, real moratoria, or even a rule that would be considered a de facto moratoria are preempted by federal law. A couple months later, they came out with new shot clocks for small cell facilities that shortened the time frame in which local governments must act on regulations, created new rules about facilities in the rights of way, imposed requirements on how you develop design guidelines and limitations as to how you want to regulate the look of these, what have come to be known as small cells. And so that came out in September. Now, for years, the FCC had not updated their radio frequency emission rules. I mentioned earlier that the FCC has the exclusive jurisdiction to deal with those regulations. I am not a technical expert. I am not an epidemiologist. I'm not an engineer. But I will tell you, over the last 2 years, I've spent a lot of time hanging out with those people to try to better understand what some of these claims are about the potential negative health effects of radio frequency emissions. And all I can give you is my experience and what I have learned. There are a lot of people who claim that this is a serious public health problem right now. It's claims that people are being injured and damaged from the existing cell towers that we have seen for the last 20 some years. There are other people who have said that there's no issue there. The FCC rules are fine. There's no health concerns. And then there's a lot of people in the middle. And those are the ones that I have found to be the most credible, both engineers and medical professionals, who have said, there are certain things that RF radiation does that we have not studied enough RF radiation, in addition to the FCC rules, which measure basically heat and the amount of heat that they generate and how that impacts a person's body. RF radiation can also impact cell structure. Now, it may be that it impacts cell structure in a good way. And we can get into details talking about that. I've talked to some medical people about it, but most of them conclude is we haven't seen anything that specifically proves that these have negative health effects, but we've seen enough to believe that we need a lot more study on this. And we haven't had it yet. So now we are basically living under these FCC laws, and we are having these facilities put up more frequently in more locations, and in many cases closer to the ground. The FCC came out with new rules in November of 2019 after almost 21 years of opening a docket to study whether they should update their rules. So I'm not sure what your experience has been dealing with the federal government, and I sometimes get a little snippy with the federal government because I'm a local government control person, and I don't like it when a federal government or even a state government tells us what we have to do on the local level and what's best for our citizens. And it really annoys me that the FCC does not mind telling us when we have to act within 90 days, but they can take 20 years to act on a docket when people have been advocating, including local government organizations, for them to update their rules for years. The joke around Washington was that our docket had been almost old enough to vote by the time the FCC acted on it. In any event, they basically came up with their decision and they said, we really don't need to make major changes in our rules, and there's nothing about small cells and 5G that are different than the rules that we have for traditional cell towers. That rule was challenged, and I'll talk about that more in a minute. In June 2020, they came out with further orders clarifying the 6409 rules. What does it mean when on a mandatory co-location, when a government has to approve a change? What does it mean to conceal a site? They changed some of their earlier definitions. We were right in the middle of working on these code changes. I know that we were as frustrated as Ms. Nelson was. We kind of thought we had it, and then the FCC came out with new rules that changed the rules again. So back to the drawing board. So we're dealing with all of those. I noted on here as the last bullet point, many of the comments that Planning Commission and staff, and perhaps you have received, relate to another FCC decision that was taken on November 5th of 2019. And basically what happened, now that I'm looking at it, I'm thinking it might be 2020, not 19. But in any event, it was a challenge. No, it was 2019. It was a challenge to the first bullet point that you see on here, the March 2018 order that gave exemptions to environmental and historic preservation laws. Basically, I'm oversimplifying somewhat. I know we have some members of the public watching. I am not getting into this in detail. I am not covering the entirety of this, but generally speaking, the FCC said these small cell sites, they're not going to have a major impact, and they don't have to comply with environmental laws. They don't have to get environmental assessments. They don't have to get they don't have to go through historic preservation reviews. That case was overturned in court, in federal court. The FCC then issued an order, November 5th, 2019. And what they basically said was, as a result of that court decision, we are repealing our March 2018 rules. The effect of that meant that the rules that were in effect before March of 2018 are now in effect again, which means on a site-by-site basis, if a site qualifies and meets the criteria that would require an environmental assessment under the National Environmental Policy Act or Historic Preservation Review under the National Historic Preservation Act, then those rules still apply. Now, the vast majority of sites, even before 2018, when this exemption was ordered, didn't meet that criteria. I have seen claims made that based on this November 2019 decision of the FCC, The county now can apply all these environmental laws and require every small cell site to go through an environmental assessment. That, in my opinion, is just not true. Now, I want to leave the door open. I respectfully disagree on the way these folks are interpreting the law. They are certainly entitled to their opinion. They may have legal counsel who has a different legal opinion than I do. Frankly, if we didn't have honest, good faith differences of opinion on what the law means, judges would not be as busy as they are today. I will tell you that I feel very strongly that this November 2019 decision that went into effect December 5th, 2019, did not create some new area of authority that would allow a county or a city to start imposing environmental assessment requirements and historic preservation reviews on wireless site applications. It would still have to be an application that met the requirements of the law before the FCC came up with their crazy exemption in 2018. And most of them, in my experience, do not. So again, area of disagreement with some of the folks we're discussing these issues with, but I wanted to tee that up for you. Just to give you a little bit more detail on that 2018 order for small cell sites, and these are not small, by the way. The law calls them, they're called small wireless. They're fairly large. If you stand next to one of those poles, you know what I'm talking about. But this has been in my opinion, a function of industry marketing to try to make it seem like, oh, this is no big deal. For a long time, we heard these described at the FCC even as, oh, it's no bigger than a pizza box on a pole. Absolutely not true, a lot bigger. In any event, the small cell order created a test to determine when a local regulation would have the effect of prohibiting service. And they imposed these presumptions for if your fees are above a certain amount, we presume you're effectively prohibiting service. If you impose aesthetic requirements in this manner, we presume you're prohibiting service. If you impose certain kinds of undergrounding requirements or spacing requirements, or if you don't act in a timely manner, we presume that these things all materially inhibit service and therefore are a prohibition under federal law. So they created these cost caps for wireless facilities, both outside of the rights of way and also rent on wireless facilities. Now, I'm guessing that the county doesn't own a lot of poles, but you think of a city like Tacoma or Seattle that have their own electric utility that used to be able to charge market value when a company wanted to use government property to put their antennas. This 2018 order both grants a right to use local property by the federal government and caps what the local government can charge for that property. They also created these new shot clocks of 90 days for existing sites and 60 days for co-location. And they redefined co-location, so it no longer means for small cells on a site that's already been approved. It's on a structure that is physically capable of hosting that site. So if it was allowed by local zoning and your rooftop of your home would be deemed a co-location if you wanted to let a wireless company put an antenna on the roof because it's physically capable of hosting a site. That's how far this rule went. That order was appealed by hundreds of local governments around the country. We were involved in that court case with about 5 other local government law firms. The Ninth Circuit in Pasadena partially upheld that order. They actually upheld a significant part of the FCC's decisions. I'm not going to read all of these points. They overturned that part of the FCC decision as to how we impose our aesthetic requirements. They still must be objective, or rather, they still must be in writing and published in advance, but they overturned the part that said they have to be objective and no more burdensome than whatever is imposed on other users. So if you have certain requirements, or if you want to impose design requirements, say on Verizon or on T-Mobile, They can't come in as they could have under the FCC rule and say, well, you don't require those design impositions when Puget Sound Energy wants to put a pole up. The court ruled, no, we're comparing these things to other wireless companies, not to any other users of the rights of way. I got into this a little bit, so I just wanted to have a separate slide here. And I just added this quote from one of the citizen comments because, again, I thought it was, they have really strong feelings about it, and I don't want to be disrespectful. I respect their opinion, but I just very strongly disagree. Not only is it not the most important change for county rights that has happened over the last 7 years, but that it really doesn't change anything from what the rules were before the FCC came up with their exemption in 2018. So, and again, we can get into a little bit more detail if we want to. You probably can't see her, but my colleague, Colleen McCroskey, is sitting right over my shoulder here in my office, and she has worked with us on this project, and she's done a bunch of work on what are the NEPA requirements and what are the NHPA requirements in order to require an environmental assessment before you put up one of these sites. And you don't meet them too often. The court case that they're talking about is the Ketawa case, where a number of tribes challenged that order. The Court of Appeals overturned it. And again, all the FCC did at the end of 2019 was they codified what the court told them to do, which is take out those rules that you had, those exemptions that you had adopted in 2018. They really don't give the county more power to do environmental or historic reviews. The rules were, if it's a federal undertaking, as that's defined in federal law, then you can require a NEPA or a historic preservation review. And for wireless infrastructure, tower construction is in one sense a federal undertaking. So I'm not talking about small cells here, I'm talking about the macro towers, because those towers require permits from the FCC, but not all wireless infrastructure falls under that standard. The FCC still gets to determine how it handles these reviews. And even for many towers, the earlier FCC rules did not require NEPA or NHPA reviews. There are these other agreements that the FCC has entered into called the National Programmatic Agreement and the National Co-location Programmatic Agreement. And basically, and this is again an overview summary, if the facilities are located in a designated wilderness area, a wildlife preserve, or if they might affect certain listed or endangered species, they require an environmental assessment. If they don't require those assessments. So again, the FCC eliminating its exemption from 2018 doesn't change the third bullet point on this slide. The FCC's order in 2020, where they made further clarifications to their mandatory co-location rules, talks about what does it mean to conceal a site. If you remember when I said if a site was an eligible facilities request, if it met certain requirements and was not a substantial change, you had to approve their modification. And they define things like if it's a tower, it could go up by up to 20 feet. The FCC said that's not substantial. County has to approve it. It can go out a certain distance. They could add a certain amount of antenna arrays. But one of the things it said was if the proposed modification defeated the concealment element of a site, then it was not an eligible facility request, and it had to go through your regular zoning process, and maybe you would approve it and maybe you would reject it. We always, and when I say we, I'm in the broadest possible way, local governments, the industry, our national associations, used to use the terms conceal and camouflage interchangeably. The FCC has changed that now. And whoops, I don't have anything on the next slide about that. I don't know what just happened there, but I'm sorry. Let me go back here. Um, the what this 2020 order said was, conceal really means you have to make it look like something else. So as opposed to some of the camouflage that we've done in the past, like put it behind a berm or a bunch of trees that will camouflage it somewhat. You still might be able to see it, but it will minimize the visual impact. The FCC has said, if that's all you did, and they want to add 20 feet to it now, and it'll be clear as day with this expansion, you're not defeating the concealment elements of the site. Concealment only applies when you've made it look like something other than a wireless facility. So when it's inside of a church steeple or inside of a clock tower or those kinds of things. Now, I think in most cases, most in the industry have agreed with us that for some of the small cell poles, when we have canisters on top of the poles, we keep all the equipment on the inside of the pole or underground. We don't have anything hanging off the pole. That counts in my book as concealment. I'm sure there are others who might disagree, but I think a lot of people would agree. But again, at the time this rule came out, we were almost done with the draft, and then we had to go back and address those issues as well. So basically what you're going to see when this code change eventually gets to the board, you're going to see modifications that will conform your code to federal definitions. These are the kinds of issues that will be addressed, not exclusively. There'll be others, but these are the main issues. And I am at this point going to turn it back to Jennifer and to Caitlin to see if they want to add anything about the specifics of the process that we've undertaken so far with the Planning Commission and with the public, and anything else they may want to add. And then we are here to answer your questions. Thank you.
Well, thank you, Ken. And Kate, feel free to correct me if I'm wrong, but I mean, the draft of the code amendments that have been through planning, are going through Planning Commission review, have gone to public hearing, have been out there for the public to comment on, and we have received many comments specific to that draft code, asking for, in many cases, additional regulation that may or may not conform with our understanding of the federal requirements. In some cases, asking for different permit steps to be followed. In some cases, arguing against the interpretation that you may have heard today around whether these should be reviewed under NEPA or NHPA. So there's a lot of input that we're receiving, and that staff is currently working on and working with Ken and working with our legal folks to respond to and to bring those responses back to the Planning Commission so that we've received the public input, we can provide the response from staff, and then the Planning Commission can go through its work sessions. And that's been our plan, and that is our plan right now. Kate's nodding, so I don't think I've said anything too wrong. And then the decision point that's being brought to you today is basically whether that's enough of a process. Is there another process that needs to be added to this code update, which would be to form some sort of citizens committee or stakeholder group, is how we think about it in CPED, to sit down with the draft even further and roll up sleeves and work on whatever additional changes they want to be worked on. So that's where I'll leave it. And I think it'll just be time for questions and deliberation about what you've heard today and this concept of a stakeholder group.
Okay, we've got 18 minutes and I could probably fill that myself. So let's just go kind of one question each, and we'll just keep going around the horn as much time as we have. Start with Commissioner Mejia.
Okay, so the timeline has been mentioned a little bit, and why does the timeline matter in all of this?
That's a great question. I'm going to look to my legal colleagues to ask, because I think the longer that we're out of compliance with the federal rules, the more every time a permit application comes through our door, we still have to comply with those federal rules, but we don't have anything in code. So it's just sort of a burden on our planning staff to try to navigate that, and frankly on our legal staff. Beyond that, I don't know, Travis, did you have anything to weigh in on? I see you.
Yeah, sure. I think that's an important question, and I see it really as there's legal issues and then there's resource issues. And the legal issues are, right as it stands, I can count at least 5 applications that come in the door where our code was not updated appropriately in order to manage it and have a clear process. In all those situations, we've had to work with counsel, special counsel in this case, and then try to be able to carve out a course forward. That is obviously not an ideal way to operate. And I'll tell you this: the uptick in applications is only going to increase. So that is at least the legal concern, just in terms of how we can continue to comply with federal law under our existing framework, which is, not to put it bluntly, it's duct tape and bale wire. The resource issue, and I think it's important to look back at the history of this project. I can count at least 1 DPA and 2 departmental staff that have been working on this project with Ken. Fortunately, Ken, I don't know how long Ken will continue to be our client, but he has been, consistent throughout this whole process. But I will say this, that every time there's staff overturn and loss of synergy, that it really does take a step back. And, there are considerable resources given the fact of the complexities. And the fact of the matter is, we've hired Ken as an expert legal consultant. At the end of the day, the prosecutor's office has to advise the county. And that's why Grace and I are in the room. And that's why we take all these steps very seriously. But, just from a practicality standpoint, there is a necessity to move forward. And, Ken, you may be able to touch a little bit in terms of the county's vulnerability as it stands. I think there is some concern. One of the first questions I had was, well, why don't we wait till all the federal law resolves? And I think Ken was very fast to say, hey, this issue is hot on a national scale. And you're going to see litigation probably play out for the near future. There is no pause in terms of the uncertainty of federal law. So the importance for us to be able to update our code now, it's very important for us to be able to meet the current requirements. We may have to build on in the future, but hopefully we can get a lot of it done. But I'll tell you, if you wait another 10 years, there is a lot of uncertainty in terms of our legal exposure, and that's kind of why we have some urgency to be able to maintain some transparent, progressive sort of approach towards getting to some kind of update that can get us into compliance. But Ken, I may have, there may be more detail you could provide.
Actually, no, I think you covered it really well, Commissioner Mejia. This is like staff is required to try to fit a round peg in a square hole every time an application comes in, and as Travis said, that it's more costly because they have to retain outside expertise more frequently. It's tougher to train staff and get staff comfortable with what the rules are when the code says something different than what some of the rules are. It just creates some risk. It's hard to quantify what that would be, I think, and that's what staff's challenge has been, and your challenge is trying to figure out how do we do this in a way that gets us to the finish line, that makes it much smoother going forward, and to do it quickly, but not too quickly that we don't adequately address all of the important issues that ought to be addressed in the process. We feel like the process has been effective so far, and what's before you now is a recommendation to change that process a little bit. I can't tell you that it would be terrible to do that or it would be great to do that, but I can tell you that I'm very comfortable with the process that we've been undertaking so far.
Okay, that was 6 minutes on that question. So I'm going to ask people to be as concise as possible with your answers. I know it's a tendency of lawyers to want to over-explain things because there's a lot of nuance. I get that. I'm going to let Commissioner Edwards ask the next question.
We've got some correspondence, and I'll just refer to one thing. In one correspondence, it said that Well, there shouldn't be any of these sites located 1,500 feet from a home or a school or, you know, where people gather, okay? So this maybe is for you, Ken, for jurisdictions that have moved forward on this process farther than we have, do you end up with anything but activist individuals wanting to serve on these community committees, I guess, if you will? And how do you keep the regulatory process in play so that they don't go off on a tangent and do something that's completely contrary to whatever the federal law is?
I'll try to be concise. Commissioner, in the most contentious public hearings in the communities where I've worked, you might get 50 or 60 people at the public meeting that are in the activist category that you described, and 1 or 2 that understand the technology or work in the field or have had some connection to it, who have said this really isn't a problem and here's why we ought to go forward. So there might be people in Thurston County who could be added to a committee that would create a balanced committee, if that was kind of where your question was going, whether that would be possible. It might be difficult. And I think just on the example that you used, so that you understand, my question to someone who would say 1,500 feet, I would say, why? And if the answer is because I'm concerned about my health, and you now have a record at your meeting that you're doing this for health reasons, you have just opened yourself up to a lawsuit that you will probably lose because you have made a regulation based upon the health effects of RF emissions. So those are the touchy issues that you're going to be dealing with, whether it's a committee dealing with them or the Planning Commission or the board.
One of the questions that I got was about the RF thermal piece that you mentioned. You said there's federal regulations there. And this person understood that and thought those regulations were okay, but thought that our proposed code just basically asked for a sort of a unilateral attestation, like somebody could just say, hey, it's good, versus having some sort of verification or proof of compliance with those federal regulations on thermal, whatever it is. I don't know the science. Does that make sense, my question?
It does make sense. Without getting into gory details, I would say that in many communities, the requirement is to, and I think it's similar to what we've suggested here, is that the applicant is required to come up with their own experts, radio frequency engineers report attesting under penalty that this site will be compliant with the federal regulations. Now, some people say, well, once it's up, you got to make them go out and test it and prove that now in operation it is. Does that get too far afield where that regulation would be preempted by federal law? I don't know. Now we're in the gray area. So some communities have not done that. Other communities have done that. Some communities that may not want to be liable have said, you know what? We can do our own testing. And you could spend $1,500 and hire an RF engineer after every approval that you do to go out there a month later and see if they're meeting federal requirements. So there's a variety of ways to impose regulations, not just in advance, promising that the site will comply, but also to demonstrate that the site is compliant. It's just a question of how far you want to go to do that.
Yeah, okay, 8 minutes. Okay, I had a question in regards to any other counties here in Washington State. Have they, are they kind of like in the same place where we're at right now? Has anyone already completed it? And maybe we can, instead of reinventing the wheel, we can get ideas from them. Do we have information on that?
Travis, didn't you reach out to your colleagues?
I could try my best. I did reach out to deputy prosecutors, Commissioner Mejia. I think we got that question before, and we were curious as well. I got a response from Kitsap County. We have also modeled a lot of our revisions based on a recently adopted code, Anacortes. We were also at one point looking at Tumwater's code. The municipalities, quite frankly, are a little ahead of us, and those are good examples that we've been modeling. We're also learning from a couple counties that have gone through it too, and so we're working with all the available knowledge we've got. I will say that, Ken would probably tell you that counties aren't moving necessarily as quickly. Now, in terms of the urgency, I don't know if that necessarily is a good indication to gauge where we are, because I think just from talking to other DPAs or counties, when I've reached out, when we do get a couple of these applications, say, hey, are you running these same problems? And a lot of times, there are some counties say, no, we're not receiving these. And then others will say, yeah, we are, and we're concerned. So, I don't know if that answers your question, but I think, it's fair to say that the counties are running behind, but they are quickly trying to get up to speed. At least that's been the trend that I've experienced.
I do think that the counties have an organization in the national level, that they probably even have an ombudsman that is probably up on a lot of this material. And I can't imagine that their laws are that much different than ours. So if you went to the national level yet and tried to see if you could get something that would fit.
Yeah, I'm Commissioner, if I'm familiar with the National Association of Counties and have worked with them before. I'm sure they have a staff person, a legislative policy person who has this kind of broadband and telecommunications in their portfolio. I do know from working with the National Association of Counties and the National League of Cities, very rarely do they come up with their own model codes that they offer to all of their members, in part because state laws differ so dramatically from state to state as to both county powers and municipal powers. What they do a great job on is advising their members of how the federal laws impact local authority. So they may have a bunch of white papers on this. I would suspect they would not have model codes that we could look at what other counties have done in other places.
You don't think we could get direction from them to say, go look at so-and-so county in Colorado or whatever?
Oh, you might. Yeah, you might get that.
That's kind of what I'm looking for.
Yes.
Ramiro, I have more questions, but I think you also said that the board needed to direct regarding a citizen advisory committee, and there was going to be an explanation from CPED of what that would look like to have to stand that up, what would be involved, what the proposal is.
Yeah, and you have the recommendation from the Planning Commission on your packet. And also staff has provided you with pros and cons as to, continue with the legislative process that Jennifer stated, or direct the staff to extend this advisory group for further recommendations, and that is the pros and cons of that is really the time and effort associated with extending this group. How that is going to be standing, what is the set of expectations, what is the outcome of this advisory group, considering what Mr. Feldman just went through in terms of the history. And there is a disagreement perhaps on some of the interpretation of what I believe the 2019 ruling, as Mr. Feldman stated, based on the public testimony the Parliament Commission has received from some of the citizens. And that's really what really becomes the conundrum, I guess, that's my word. Whether this extending this advisory group, what will be the set of expectations, what will be the potential outcome in terms of validity, of the value added to the process itself. Considering at least from, I have been involved to a high level for the last 2-3 years on this FCC regulations, and the more that I was listening, the more restrictions the county has in the latitude the county may have in implementing the new code is very limited. So it is a question for the board, based on what you're hearing, whether you can see the value of following the Planning Commission recommendations to extend this advisory group, or just perhaps the option of continuing with the legislative process. As Jennifer stated, we have reached out to the citizens. The citizens have provided perspectives. And that's where we are, I guess.
Comments on that?
I guess I would opt for maybe staff, along with council, to come up with some type of a draft proposal that meets all the federal regulatory processes as we know them now, and then have that be reviewed by a group, because more than likely, it's gonna be a group that's opposed to what we're doing anyway, and we're gonna have to try and follow federal law. So to put them in there too early, it almost seems to me that they're gonna make every effort to shoot everything down. I mean, I'm just basing that on that one letter that was quite an extensive letter. So I'm not against the citizen involvement, it's just that it looks like they're probably not gonna accept, they wouldn't be so inclined to make recommendations to us that include all those other portions that meet federal law. I mean, I don't see that we've got a choice. We're almost like, what's the point here? Almost.
And if I may, that's really the gist of it, as I understand it. The proposed code revisions, they have been provided to the planning commissions and for citizens reviews, I believe addresses your what you were asking is, that's the outline as to how the county code, the proposed county code can be aligned to the new FCC regulations.
Jennifer, can you speak to, sometimes you're able to speak to the planning commission's kind of thought process? I mean, they are this, like, sort of the citizen group that's taking this in. They've had work sessions and they're gonna have more work sessions.
Mhm.
So it's unusual for them to basically subcommittee themselves and say, we wanna create our own subcommittee to give us input. What was their thinking about that?
Well, I'm not going to try to interpret their thinking. I do know that they were listening to community members asking for this, and they want to be responsive to that. And if I were to hazard a guess, I would say that the Planning Commission, I mean, the complexities of the information are clear, right? You've seen a PowerPoint. It's complex. There's a lot of nuance. There's a lot of detail. It is a lot for a Planning Commission to absorb and deal with and have public comment on. That's why we plan out several additional work sessions with them to work through that public comment and potential areas we can further adjust the code or whatever it is that we're going to be discussing. So that's the normal legislative process. To ask for a subcommittee at this stage of the game after public hearing and before having those work sessions, it's a little unusual in terms of our normal process. But I think it's something that they felt they wanted to be responsive to the community and get some additional help trying to understand the implications of this to the local community. And I think that's where they're coming from.
Okay, Commissioner McGinn.
I don't know, I'm still trying to soak this in. I just, I'm not opposed to having a citizen advisory committee, but I don't feel there's a lot of wiggle room here anyways, because we're just trying, you're basically under these guardrails of federal guidelines, and I'm soaking it in.
I'd like to have another discussion on this at some point. I mean, not in the not too distant future. I mean, we had an hour set aside, but we did 40 minutes in a presentation that, it was a good presentation, but we're always left with very little time to discuss it and come up with solutions. So that's kind of where I'm at.
Sounds like the board is not ready to give
Yeah.
requested direction.
So, how about if I'll bring this, would July 6th sounds okay? Jennifer, Travis, Grace, I will bring that as part of, the regular decision time. That'll give you 2 weeks.
Well, and even, don't we have a work session coming up all day or something?
August 13th.
That's August 13th.
Oh,
That might be
geez, I
too
thought we
late.
had one coming quicker. Yeah. Okay.
Maybe July 6th, I will bring
Yeah.
this item again, and at that time, the board can probably reach out to staff, myself, or anybody have any questions. But I think the framing of this conversation, I think, has been well stated today, I believe, in terms of the limitations the county has really in taking more than probably beyond what the FCC will allow us to do. And that's really the crux of it, I believe, in terms of the decision that you may have related to standing on the advisory group. Because what will be the value and the expectations they will impose to this group if the restrictions are, as Commissioner Mejia stated, the sideboards are pretty tight.
Let me just make one real quick. The chair asked, you know, if, what they were thinking, the planning commission. I heard that maybe last week or earlier this week. What were they thinking? Why don't we have somebody from the planning commission come forward and so we can ask them, well, what are you thinking about that? You know, is your status as a citizen group here gonna meet the requirement of a community group? Or do we go out to a community activist group and see what, you know, and then try to balance it out? Cause I think Ken's got it pretty well hit. I see he's got his hand up too.
Go ahead, Ken.
I'm sorry to interrupt. I'm going to be on vacation July 6th. Now, if you want to do it, then I may be able to break away and spend a bit of time with you. I'm willing to do that. I know this is an important issue. I don't know if you have any other flexible. I'm not going to be back till the 16th, so I can do it then. But I might not be wearing a shirt even as nice as this.
All right,
Seeing
well,
you. Okay.
thank you. That's good for us to know. I mean, I'll say that I'm leaning toward it because a couple reasons. One is I think there's two things that can happen. You can delineate those places where the sideboards are tight, but I heard 2 or 3 areas where there is some flexibility in gray area, and those are maybe areas that the committee could help. And I'd probably be 50-50 on it, but with the planning commission having gone much further than I've gone and feeling like it would help, that I'm not seeing any reason today to not defer to that recommendation of the planning commission because they've thought about it and it's gonna go directly into their work. So if they see the value of it, I don't wanna block it. But I think maybe the board can take this up on the 6th or at another time if Romero decides it's necessary to change that date.
Let's plan for July 6th. I think what Mr. Feldman stated, you know, it stands on this outline
Yeah,
very clearly.
I kinda know what I want.
I think it's more of a legislative action in terms of the value added
Yeah.
from what you heard today, whether it's a value added standing this advisory group. So if Mr. Feldman is available, that would be great. If not, I'm sure with our pristine attorneys, Grace and Travis, we can cover any legal follow-ups on July 6th.
And if the chair of the planning commission, you know, wants to be incorporated, or if the board would like that, I don't have any,
I'd kinda like to hear what they're thinking. I
Maybe
don't,
we can
I don't
reach
have
out to
a problem with
Mr. Jim Simmons to see if he's available on the 6th. And just to see if he can provide additional perspective from the planning commission as to how they concluded on this recommendation.
Yeah, I'm happy to reach out to Jim on that for sure.
okay. Thanks, everybody. We're good?
Thank you. Very good briefing. I appreciate it.
we're going to a new Zoom.
New Zoom.
New Zoom.
Thank you all.
We're adjourned. Thank you.
Thank you, Ken. Good to see you.